You're listening to the Privacy Casebook Diary.
And in each episode, we discuss and review a data protection case or matter.
We hope you enjoy the content we share.
And hopefully, you'll learn and grow together with us.
Hello, I'm Cristina from CVG Solutions, and I am a data protection practitioner dealing with all data protection matters, including data protection officer.
Hello, and I'm Michael Mulholland from Spencer West, and I specialise in data protection compliance and AI compliance.
Okay, so today we are covering a really interesting case. It's X, which was the claimant, who was an individual, taking action against two defendants. One is the Transcription agency, and the other one is Master Jennifer James, who is a cost judge. The first defendant, which is the Transcription agency, they provide transcription services of court hearings to the courts. What happened in this scenario is that X and the second defendant has had previous dealings with other cases where the second defendant was called in to make a judgment on cost orders. Some of them were in favor of X, some of them were against him. And all of those were subject of a detailed assessment by the cost judge, which is the second defendant. Now, during the course of this proceeding, which was around about March 2021, X lodges a complaint with the Judicial Court Investigation Office claiming misconduct. Judge has acted in a misconduct way, but by the April, those complaints were dismissed entirely. He then complains now to the Judicial Appointment and Conduct Ombudsman, challenging the JCIO handling of his complaint. When also that one doesn't go anywhere, then on the 28th of April 2021, X makes a SAR, and this is where the interesting bit comes in. So he submits the SAR to the court. Timeline is really important because one of the claims that he makes is that the defendant, in particular the second defendant, was late in her response, outside of the 1 month timeline that the GDPR sort of prescribes. But both defendants, they claim judicial exemption for not providing the data to the claimant. So what this case does is that it looks at the scope of the judicial exemption, whether the judicial exemption applies to this case, the facts of the case, and then obviously the delay, whether there was indeed a delay in reply. So the SAR was sent on the 28th of April. The letter was actually sent to the Royal Court of Justice via recorded delivery, and it was signed on the 30th of April. Then, but the second defendant, doesn't actually open it and see it until the 13th of May, and there is a record of that, of her opening on the 13th of May. Now, the claimant, so X, Mr. X, on the 2nd of June, so, literally not wasting any time, send a letter straight away of claim to the second defendant saying that, you're not compliant with the SAR. What the judge says in terms of the timeline is that, well, she can't respond until she sees it. So basically there is no delay, and so he dismisses the argument, straight away. So the timeline that the judge uses, and let me find it, I think it's incorrect. Well, it's not incorrect, but I would actually challenge it in terms of because what the judge says is that the defendant could not be treated as having received a SAR until she had given the letter. So that would be the 13th of May. And so then, but then he said the latest that her response would have been posted was the 2nd of June. So basically, he says, there was no delay. And says, it says, the second defendant could not physically respond to a SAR before receiving it. In this circumstance, the claimant has failed to meet the burden which lies on him to prove that the second defendant responded outside the period of 1 month. This part of the claim is dismissed. The regulation says that the timeline, if you want, the clock start ticking from the moment you become aware of the SAR. So if she didn't become aware until the 13th of May, well, in my opinion, the due date should be the 13th of June, not the 2nd of June. What do you think on that?
I'm not sure. Could you explain what you mean by that? Why?
So the judge says that the timeline would have ended on the 2nd of June.
Oh, I think what the decision was that, okay, that was, although they're out of time, they didn't think it was a significant matter.
It was so it was just 1 day delay because the SAR was due on the 2nd of June, but the letter, so the response, was received on the 3rd of June. So there's just 1 day delay, and therefore, it's just it's
yeah. I think that sort of indicates the unreasonableness of X in this matter, because okay, there might have been an error, they're outside some procedural rules, but the decision here said they took a pragmatic approach to it and took a perspective.
But in terms of the timeline, she did not read it and opened it until the 13th of May, so that's when the clock started ticking. Right. And so the 1 month should be the 13th of June.
Yeah, it wasn't in her knowledge. Right. Yeah. So why did you write to the court then? Because normally because it sounds like there's a merge. They're trying to merge the court. I mean, the DSAR's data protection legislation, and then you have the court, which is just the litigation.
Yeah.
And then getting the DSAR involved by getting the DSAR activated at the court. That sounds like, well, they shouldn't really mix in all in. Keep the two things separate. And that's probably what causes delay as well, because there's well, just serve it to me directly or write to me and let me know. Give me a chance so that I can actually see it. Yeah. And then with courts nowadays, they're so busy and they've got so much paperwork to deal with and the like. I mean, that's
and that's interesting because the judge does say that in terms of that if you want to complain about the outcome of the cost hearing, where the judge, the second defendant made her judicial judgment, then you need to go to the Court of Appeal. You don't use this, data protection for that purpose. Okay, so that's why the appeals are there. So it's actually sort of rebooking Mr. X to say that you are using data protection for the purpose that is not the purpose. Do you know what I mean? But there is a really interesting discussion between the various parties and the judge about what constitute judicial exemptions. So the claimant sort of says, that we should view it in a narrow way. So in terms of it should only apply to the judgment that the judge does, not to the administrative task that sort of surround the judicial establishment, if you want, or processes. While instead, the two defendants argue that it should be interpreted, broadly. So everything that, all of the activities within the judicial are to be considered, part of the judicial exemptions. And one of the things that the judge says is that judges are not liable for being, taken to court, sued for their judgments, because they have to maintain that the freedom of repercussion, do you know what I mean? And so their liberty needs to remain. So there needs to be free of fear of repercussion from the judgment, basically. It says that the judicial exemptions applies to everything that it's within, an activity of the judicial system. But what's interesting is that the judicial system, they also have a data protection guidance on how they should deal with SAR. So if everything that the judicial establishment does falls under the judicial exemption, then what's the guide for?
Yeah.
Do you see what I mean? Because there might be.
I see. I mean, because if everything that we do, because if it's interpreted broadly, anything that's associated with any of the judicial function will come under the exemption. So
yes,
what do we need the guidance for? So I understand. I haven't read the guide, so I just have to. I don't know if you read the judicial.
No, I've not read the guide. No. So it says that the consideration of the judge is that immunity of judges from civil liability is a hallmark of a democratic society and has long been recognized by the common law. The absolute freedom and independence of the judges is necessary for the administration of justice. And then it says, access to personal data is not a vehicle to root out information about a judge. So it's quite clear. And it says that, a Data Protection Act is not a mechanism for holding judges to account. That's you do that through the right of appeal. So that's basically what he says. So the other thing is that the both defendants, they use the gasket process to determine whether to release the data or not. So that was really interesting because gasking process. So the essence of this procedure is that public authority should consider a SAR in 3 steps. First of all is, does the request require disclosing information that identifies a third party? 2, has the third party provided consent? And 3, is it responsible to disclose the data without the third party consent? So they have applied that quite judicially. Right. Then another reference that the judges make is recital 20 of the EU GDPR, which states that the competence of the supervisory authorities should not cover the processing of personal data when courts are acting in their judicial capacity, in order to safeguard the independence of the judiciaries in the performance of its judicial task, including decision making. So it is recital 20 that basically is makes the deciding factor for the judge to say that the exemption it's for everything. In other words, and then in terms of timing we discussed, but then there was another point that was relevant to this case. It's whether the first defendant, who is a transcription services agent, whether they were a controller or a processor. So the way it works is that they are a third party basically to the court system. They are engaged through a bidding process, and then there is a contract in place. And this contract says that for certain activities, particularly transcription services, they are the processor. They are the controller for other things. And obviously the second defendant, it's considered a controller. And the reason for that is because the transcription agency, they get the recording from the hearing, from various hearings. They then obviously transcribe it, but then it goes back to the judge for the judge to review and approve before it's made, available. And so that process that justifies the fact that they are the processor. So yes, so also that claim is dismissed basically, because the transcription agency could not possibly give him the transcription without the judge approval, because the judge or the second defendant is the controller.
Yeah, thank you. That was a very detailed summary there of what
Sorry.
happens. A lot of issues. No, that's a good thing. It's a good thing.
I mean, I did enjoy reading it, actually. I've learned a lot from these. And it's quite interesting to, this case actually kind of takes away any doubts in terms of when does the, judicial exemptions apply, or, the scope of it, rather. Because, it makes it very clear we need to look at it from a broader perspective.
Yeah, so I mean, it seems that X was sort of trying to attack the judge, and so they had their first set of proceedings. I don't know how many cases that was, and it didn't go their way for X, and it seems that they're on this path of litigation. They got the judgment, and then they're using a non-litigation route, the Data Protection Act, 2018 Act, to peel away, to chip away, to put a hole in the, and to reopen the case if they find something else. So they're almost like relitigating, and so they're using the DPA in a way which is not supposed to be useful. So that was a proper example of a fishing exercise. So that's a fishing expedition. So that's what they said. That's a common phrase, and this is a perfect example of a fishing expedition.
Yes.
And also, there's the Durant case was mentioned there, but it was also a good example of what the delineation is between litigation cases and the data protection sort of regime. And then it's the sheer bloody mindedness of this, because it's like if you're gambling, right, I'm going to double my losses, or I've lost, and let's go again. And I think that's why they were sort of very harshly punished overall, because first of all they're looking to maybe sort of attack the professional credibility of the judge. You can't really. I
cannot take away the feeling that it feels personal. The X has a personal vendetta, so to speak, against Master Jennifer James, because he reports her to the JCIO, not happy with that. Then he reports her again to the JACO. Then now the SAR. Do you see what I mean?
It's almost bullying, isn't it? It's the sort of tipping it, and it would make the job impossible if the judiciary were unable to make considered judgments and then face personal attacks afterwards. I think, and then that does go on. We see it in the national press and decisions made again, and that really starts undermining judgments. And this here, I was saying, well, the judicial freedom, the independence, that's got to be preserved. And then all the little tasks, well, the administrative tasks associated with it, which what transcription services were doing, that forms part of the whole. What the judicial way of it, how do they do their job, they fulfill their role. So the outcome here was that the costs were very
so he loses across the board on this particular case, and he gets punished for it.
Well, therefore, it came all together. It came together a 500,000 cost order. So just for pursuing this, and it should be obviously with some advice. You said I wouldn't go down this path, or someone should say you shouldn't pursue this. And if he hasn't taken any independent legal advice, but because it was a 3-day trial, so that's expensive in its own matter. and then he was responsible for paying the defendant's costs for everything that they'd spent. So it totaled £500,000. There's 249,000 just to transcription.
Yeah. Well, the better option would have been to just go to appeal. Appeal the case.
Yeah.
That would have been the right procedure or next step if you're not happy with it. If you think that there's been some kind of misconduct, rather than use data protection as your weapon, which backfired, drastically for him. And to be honest, rightly so, because that's not what data protection is there for.
Yeah, I mean, the court called this case misconceived, and it certainly was. So
yeah,
well, there's a lesson for everybody, and it's like you can't waste court time.
No,
because there's a price to pay there for that, and he certainly, well, he or she, I don't know if X is male or female.
it's a man. From what? Yeah, because he's referred to a him, so he's a man.
Yeah, I don't think they applied the Gaskin test here, because they thought it was it wasn't appropriate, because we're just relying on what's in the DPA, and part of the part of the reason why he wanted to use the Gaskin test was then that might again, if he starts opening up the balancing test, he might find out things that he would latch onto, and he'll want to pursue that further. But it was a very emphatic, unanimous judgment in favour of the judicial exemption.
Yeah.
So as we said, interpreted broadly, and it's be interesting to see, as you say, when it wouldn't be, when it would be interpreted narrowly, and when you could get into that. But for me, it was an interesting case for that, because of the fishing expedition element of it, and for just advising people, do not undertake litigation, because it is a serious matter, and really.
Yes. But I mean, from a data protection perspective, for me, it's helped to really define the scope of the judicial exemption. If we have ever had any doubt how broad or narrow we should take it, well, now we know it needs to be broad, and certainly this case has made that.
And also the lines of discovery under litigation, and the DSAR regime as well. So finding things out about yourself, but never the twain shall meet. They keep two processes separate. So that was a good little exercise.
Yes, it was. Well, as I said, I enjoyed reading. I mean, the second part was quite technical. I mean, the judge went through a lot of consideration with regard to the data, and to make sure that it wasn't being disclosed to any to any of the party, even unintentionally. And it goes through a lot of really, what's the word, detailed consideration of the best approach on how to do that, so that he can determine whether which party is right in terms of should it be disclosed, should it not be disclosed, and so he does that quite efficiently, I think, in my opinion. So he doesn't just brush over it. So no, really interesting. But I suppose choose your battles carefully.
Choose your battles carefully. Don't be reckless. All right. Okay. Well, I think that's covered that one quite in some depth. So thank you very much, Cristina.
Thank you, Michael. Speak to you next time.
See you next time. Okay.
Bye.
Bye.